All right, welcome everybody. Brett Pollock, will you please come up and give us our invocation?
You need to turn the mic on.
Oh, okay.
Will you bow your heads and pray with me? Heavenly Father, thank you for this day. Thank you for this beautiful town, Bradenton, Manatee County. Pray for our club, all of its members, and those members who could not be here with us today. Pray for the children in Manatee County and their families that we give so much to, and make sure they are living healthy lives in our community. We say this in your name. Amen.
Join me in the pledge. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now,
cue us, Mac. Okay, you all may be seated. You know, it's going to be one of those days when your program speaker comes up to you at 10 after and says, I can stretch it as long as you want. Sean, we should just start you now. And then Mac has stuff going, so everybody just starts, so we're good.
Switch.
Of course, the mic's not on, but that's okay. There we go. So everybody, please enjoy everybody's fellowship. And we'll be back at 12:30 for our program. All right, welcome back, everyone. We'll begin the program portion for today. At this time, could I have John Mullis come up and introduce our guests? That's for me getting off the stage.
That's right. Cheers for Neil getting off. All right. Good afternoon, everyone. We have 3 guests today, 2 of which are guests of Christian Trong. We have Tala Sadiq and Shannon Live. And then we have Henry Lawrence, guest of Ray Bellamy. Thank you, everyone, for coming.
The power of a new member bringing guests. Thank you, Kristen. All right, Mike, is there any community service?
I'll just say it from here.
Okay.
August, we've got White July. August 8th, we do have that event at Manatee Elementary, and we could use some help grilling out hot dogs and passing them out for the children and the staff over there. So we'll be talking more about that, and that's all we have.
Okay. All right, the club board meeting is tomorrow at Fusilli's at noon. And we want to keep in mind Rita Smith, who is up at International this week. She left this morning, so hopefully she'll have a great time up there. We do have room for people to go to the district convention in August at the Omni around Orlando. So if you're interested in going to district convention, please let me know in the next couple of weeks and we'll get you signed up and have a good time there. Mike, do you want to introduce our guest speaker or just for fun? And remember, our guest speaker said he could last forever. So stretch him out.
We're glad to have you today, Sean, and I've already heard everything from you so far, but the rest of the audience here today needs to hear it. But we invite you, you're going to kind of pull together some of the recent meetings that we've had with regards to some of the children going through the system for the most part. But we welcome you as a member and as a speaker today. Sean Powers.
Okay, so the genesis of me volunteering to do this is we've had a lot of recent programs that touch on foster care and how, the kids are there, and every table I've been sitting at, people have asked questions. I wonder what's going on with the family during that time and things like that. Now, I have done practice dependency in front of Judge Smith, in front of Judge Dees. Judge Inman looks to have stepped away, but she's done it as well. I know that Judge Nicholas was on the dependency bench for a while. And so this is going to be about dependency, which is when DCF comes and takes your kids away. But it's going to be more from the view of the kids and view of the parents, because that's what my background is kind of in. So there's actually, if you go to my website, which is mcnarypowers.com, I've got an article up there that I wrote about how these investigations start. And the way that they start is with, well, what you need to know about me, I started practicing law when I was 40. My first job was defending the parents in this system. And they're under investigation for abuse, abandonment, or neglect. You're kind of getting my perspective. I'm going to try and be as neutral as possible. But I'm not someone that's in favor of abuse, abandonment, or neglect, but I have had to defend some people that have had to deal with that. And I just happen to know this area of the law. There's not a lot of attorneys that practice in this area. A lot of people think it's family law. It's not family law. It's under very different rules, and it's not criminal law, even though those things do intersect at times. So that's abuse, abandonment, neglect. Those are all felonies. So that's where I kind of started this presentation one time, was to show this to criminal attorneys and family law attorneys so that they would understand the way that it can intersect with their stuff. So it starts with a call to the child abuse hotline. All right, the child abuse hotline receives information, they make a determination, and then they send it down. Here they send it down to the sheriff's office. Other counties, they send it to a DCF worker. They go out and they investigate. That investigation, this is a part of the Florida statute, 39-301 sub 5. It's one I have memorized because I spout it off in court all the time. It reads that any subject of an investigation shall be informed of the following rights. Now, at this point, you don't have a right to an attorney, but you have a right to stop and go consult with an attorney. That's spelled out in this section of the statute. I would argue that because it says any subject, if you're a school teacher who's being asked questions about, is this kid coming to school with bruises, or you're the next door neighbor who has some kind of fact information about the investigation, I would say that this statute applies to you as well, and you should be informed of all these things. And the reason I say that is if you go down to the bottom, it distinguishes parents and legal custodians from up the top where it says any subject. So the top part, I think, goes to everybody. The part about legal custodians or parents just goes to parents. So that call goes in, and then you end up, there's a 60-day time period where that investigation can remain open. Now, this is an artifact from a school presentation that I did, but if anybody in here is working at a school and you're brought into one of these interviews with a child and you're an employee of the school, but the kid gets along with you really well, they think it'll make the interview go well. If your school maintains a separate record of that interview, you're committing a misdemeanor. And most people at schools don't know that. So, okay, so then what happens after that call goes in? Like I said, there's an investigation. It can go nowhere. It can be, we're going through a nasty divorce. I hate I hate the new girlfriend, so I'm just going to keep calling DCF. If you keep doing that over and over in bad faith, you're actually committing a felony, but it's difficult to prove those. It can go to what's called a safety plan. Safety plan can be, we call up, Aunt Sally, and she's going to make sure that the boyfriend who was accused of being abusive is no longer in the house. There's case management, or it's the investigators are involved at that point in coming by and checking and saying, are these, maybe we're going to do a couple of drug tests or something like that. And that can last and stay open for, like I said, 60 days. And they usually do stay open the full 60 days because to close one down, you got to go to the supervisor and then go to the supervisor of that to shut one down. It can go to a shelter hearing. A shelter hearing is a hearing in front of a dependency judge, or on the weekends it could be a duty judge, where the events that are leading up until that point are given to the judge. At this point, you're entitled to an attorney, just like you would be if you got arrested, because there are certain things outside of criminal law in Florida where you are given an attorney. And at that shelter hearing, parents are allowed to provide evidence if they have any. Usually it's an attorney from a place called the Office of Regional Counsel that is there, is assigned, has 2 or 3 minutes to read over this report that's been filed with the court, and then try and come up with a way to explain why what's being presented should not lead to the children being removed. And then it could also lead to what's called a Chapter 39 injunction. A Chapter 39 injunction is like, everybody's familiar with like a domestic violence injunction, those sorts of things. Chapter 39 is its own peculiar monster because that is where a person who's not a parent has an injunction put in place to keep them away from a child or children. Those can last up until the kids turn 18 years old. They can only be modified by the court. You can't stipulate to it. You can't say, well, the kids are 15 now, and they want to be able to hang out with me. They know how to be safe. You can't do that. You got to go back to the court that has retained jurisdiction on those. So, all right. This is the safety plan that I was talking about. So, in this safety plan, like I said, it can be up to 60 days. You're not entitled to an attorney, but you need to be informed of your right to consult with one. And actually, the kids can be removed from the home, but you would consent to it at that point. So you're agreeing, as a parent, you're agreeing with the investigating agency, whether it's the sheriff's office or DCF, like, okay, I'm going to take a step back. Kids are going to go live with my brother for 2 weeks while I straighten out these environmental hazards that are in my house. Which could be anything from people aren't cleaning up after their pets, rancid food, those sorts of things. Like I said, up to 60 days, the length of an investigation. This is something that not a lot of people know about, although there was a recent change in family law statutes which kind of gives grandparents some rights to visit with their children. But while children are in foster care or relative care, as long as DCF is overseeing them, grandparents actually have a statutory right to visit with their children. It's got to be in the kid's best interests, obviously. You can't be, the court can cease that at any time because sometimes the grandparents are the reason that the parents have made so many mistakes that has led to the kids being in foster care. Now, the interesting thing about this is if the parents' rights end up getting terminated by the court, meaning there's a trial or a consent and you're no longer the legal parent of those kids, the grandparents' rights to visitation remain in place, which is kind of a peculiar thing. I guess I understand it. It's just one thing that it is. And this leads to me on occasion now, I get calls from grandparents, and I do represent them in court, where they can be at what's called and I'm sorry, this is just stuff that I all know by heart, but you can become a participant as a grandparent, but you're not a party at that point. And there's a distinction between a participant and a grandparent, or I mean, a participant and a party, in that participants are not supposed to be filing motions and making arguments, but they are allowed to be meaningfully heard and get notice about any court hearings. The 39 injunction, you're not entitled to an attorney for one of these, which in some jurisdictions in Florida, I think is an end run around a parent's constitutional right to have an attorney when you're trying to terminate their parental rights, because if this is, usually these are used against an uncle, maybe a step-parent, I guess maybe like an evil teacher who's doing inappropriate things at school. This is a person that doesn't have a familial relationship, a parent-child relationship with the subject child. They can be granted what's called ex parte, meaning you don't even know that it got granted. You'll get notice of it at some point, but if it's a severe enough emergency, one of these things could be entered against you, and you don't even know it, and then if you call that kid on the phone, you're committing a crime without knowing it. They can be reheard within 14 days. Now, for the attorneys in here and people that are familiar with the law, that's not a lot of time, especially when there's not really an opportunity for what we call discovery. So you're not going to be able to set a deposition, see what evidence the state has and that they're bringing this. And these can actually be brought by any person. I have filed one of these myself, and I don't work for DCF. It just needs to be, the statute lays out who can bring them. Obviously you can't bring it against a complete stranger. You're going to have a nexus between the behavior that you're talking about and a possible danger to the child. But grandparents can file these. Technically, if a teacher was worried enough, they could. The one thing you do got to have, though, is an investigation. And so that's why it's almost always going to be DCF, or locally we have a group called Children's Legal Services that does the legal work for DCF. But that investigation by someone has to qualify in order for one of these to get granted. And again, can last up until the child's 18th birthday. Okay, so then maybe we go to the shelter hearing. This is just a little more detail about that. Like I said, you will get appointed an attorney at the shelter hearing. Sometimes there's enough attorneys there. Sometimes someone has to stand in and just for purposes of the hearing represent what they think the argument would be for the mom and then the dad, even if their interests are not aligned. That would be a very provisional appointment, but that is possible. And I still carry this case around with me, this LMB versus Department of Children and Families, in case I ever find myself as a shelter hearing, because I don't even know if I can read it. If a parent is not permitted to be heard at the hearing and only the department's evidence will be considered, then the one-sided hearing would be a pointless formality. But I think that's really powerful language in that we got to try and tell the whole story at some of these hearings. Now, the issue really is 99% of these cases, there's something bad going on in the home or somewhere else where there is a safety issue for children. But sometimes it should really only be one parent that's getting affected by it. Sometimes it's the other way around. If you end up here, there is a very good chance, and this is something that I don't think people realize, that the Department of Children and Families is going to be in this family's life for at least a year. At least a year from that date. Okay? So, now that's the cases that I'm going to describe moving forward. But the idea that, like that Isaiah 177 group that was here, those kids, if they build those houses and as the kid goes into that house that afternoon and that whole process starts, we're at least a year, if not 18 months before DCF might be done with that family. So it seems, a year is not that long, but it seems pretty long when you're dealing with this system for the kid and the parent. So at the shelter hearing or soon thereafter. The Guardian Ad Litem program, who I know has come and presented here before, that's a statewide program similar to the Department of Children and Families. If you might hear in a family law case of a Guardian Ad Litem getting appointed, those are not this program. This is a different program. They just use the same terms. There's going to be what's called an arraignment, and it's going to be within 28 days of that shelter hearing. There is a speedy trial type provision that can be invoked. Like I said, I could talk about this forever, but at that hearing, there's a new petition that's filed separate from the one that was at the shelter hearing, which could be, it could add facts to it. It could take some facts away that in the heat of the moment we got caught up and believed everybody, and now we further investigated, and it's not as bad as we thought it was. So then you can, you as the parent, with the assistance of counsel, you can admit, you can deny, and you can consent without admitting to the allegations. I've never allowed a client to admit, because why do that when you're being presented with a case plan and you have this option of consent without admitting or denying the allegations. If you put a denial, that's like a not guilty verdict, or not guilty plea. Often you ask for mediation, and maybe in one of those, you know, the facts could be, they're saying they want me to do a mental health evaluation and follow all recommended treatment. I'm saying I have no mental health issues. Okay, yeah, maybe I got the substance abuse issue. The meth that you found was in my pocket, but but I don't need to go over to Centerstone and have my head shrunk. So maybe you go to a mediation and you work out some of those details. Maybe you don't. Maybe you go to trial. And we do have a mediation program here locally. It's run by our court system. They do all of these dependency cases. And when you do go to trial, there's no jury. We don't hold this court, it is an open courtroom, but we don't hold it open the way we hold open so many other ones. People can go in there, except in certain circumstances, but it's just you and the judge. So if you get a case plan, again, that's how most of these cases resolve at this stage. It includes tasks or things you got to do as a parent. It could be, like I said, a mental health evaluation, substance abuse, some real standard ones. You got to have prove that you're making, that you have income and that income is legal. Because if you just show up every week and say, hey, look, I got $5,000, well, how are you coming up with that much money without a real job? Probably chances that you're doing something illegal to get that money, which should then place the children at risk. So there's a lot of thoughts that go into this. Compliance with the case plan is heavily relied upon when the judge is making decisions. So the judges want to know, okay, well, how many parenting classes have you completed? How many, what are the drug screens that you're being sent on looking like? Questions like that. And the easiest metric for the judge to measure that by is the reports that are generated every 90 days and then submitted to the court that explain that. And then, sometimes there's disagreements between the parents and their attorneys and the department. When I say the department, I'm talking about DCF, and that's when we have contested hearings about, no, I have gone to this many drug tests. And one thing that I try and do with these types of cases is that I try and hook up people that have a case plan. Sometimes they're also on probation. And a lot of the things probation is going to ask the parents to do is what this case plan is asking them to do, which is drug screen, don't get arrested, things like that. So I try and make sure that those two systems talk to each other sometimes, because otherwise these parents might be doubled up on what they're having to do. If they've got to do drug screen for the Safe Children's Coalition and they have to do it for probation, I don't know how they're ever going to make it to work, and they lose their job, and then everything starts to fall apart. All right. And then we might move to what's called a termination of parental rights. That can be asked for from the get-go. You don't necessarily have the dependency portion and the opportunity to work a case plan, but that's got to be in a very egregious case. I can't even read it from here. There's factors listed, and they're really awful things. You're responsible for the death of a sibling. I have one where the father murdered the mother. That's a ground for termination of parental rights. Just listed things. Often, though, we get to this after that parent tries to work that case plan and they can't get it together. Okay. These are just some portions of 39902 that I put there. Now, the parents at any time throughout all this actually have an escape hatch where they can say, I want these people to adopt my kids. And then those people move to intervene. It's a whole process, but there is a way for the parents to just pull the parachute cord on this and get out of everything. But you don't see that happen that often, but it does happen. Okay, so now we're back at the termination of parental rights phase. And then they have the same option: admit, deny, or consent without admitting or denying. Now, what's important here is you can hear and imagine feeling awful for the parent didn't even show up for their trial, right? It's set for a trial and the parent doesn't show up. There's a big difference between an involuntary termination of parental rights and a voluntary termination of parental rights. In that, if it's voluntary, meaning you throw your hands up and you say, my kid's going to be better off with the people that they're with, let them adopt, and you just turn around and walk off like Cain into the sunset, then the next time you have a kid, so if you get your stuff together in 5 years and then you have another child, the state doesn't have this ability to just walk in and take your kid from you. Because they can, if you've previously, those things that I was talking about, killing people and stuff like that, if your rights have been involuntarily terminated, meaning you went to trial and you lost, now the state doesn't necessarily get to re-terminate in the future, but there's a threshold that they have to get across to even begin that. And an involuntary termination in your past is one of those factors. So there are plenty of attorneys that practice in this area. When you explain that to a parent, they might say, I want to have a kid in the future, so I am just going to walk away from this. Voluntary, like I said, you could just not show up, and that's just called a consent by not showing up. You've consented to the petition, a default's entered against you, your rights are terminated, and then there's more stuff that happens with the kids. The court retains some jurisdiction for a while to get some additional evidence. You might go to a mediation and have a mediated settlement agreement, and what those are really good for is when grandma has the kids, mom can't get it together, but we're going to come up with an agreement that outlines an opportunity for mom to be able to visit in the future and hold grandma to that agreement. We actually get what's called a mediated settlement agreement. Oftentimes, if the kids are in real foster care, this isn't really an option because we don't know who's set to adopt the kid, so there's no one to come up with an agreement on. And sometimes a simple consent is in your best interest. If you do have one of those cases, like I talked about, where you stand accused of killing somebody and we're going to move forward with this, your criminal case is moving along a lot slower than this is moving along. And you don't necessarily want to be forced to get on the stand and give testimony about what happened, because then the state attorney's office just go get that, and now they got the slam dunk, and they can just stop investigating on your criminal case. So it might just be in your best interest to say, I'm good. Now, like I said, involuntary, that's a result of a trial. It exposes you to future removals of other children that you might have in the future. This is something that I do on a voluntary basis, because lawyers are supposed to do a certain amount of pro bono work. So I take these cases as an attorney ad litem, totally different from the guardian ad litem. When an attorney ad litem, there's a statute, and they almost changed the statute this year, but they didn't. There's these statutory qualifiers that if you're a kid in foster care and any of these apply to you, then the court has to appoint you an attorney. That guardian ad litem program has to go out and try and find someone that'll do it for free. They text me all the time. Or if you get appointed under this statute, you can get paid some money from the state of Florida. It's not very much money, but it also opens up additional funds if you want to do things like depositions or try and hire experts and things like that on behalf of your child, the kid that you're representing. The thing that's difficult for people to understand about this is, as the attorney ad litem, you're the child's expressed interest attorney. You're not the child's best interest attorney. So you see, being placed look at D, being placed in a residential treatment center, being considered for a placement in a residential treatment center. That's essentially a mental health facility that's locked down. 16-year-old girls that have been human trafficked don't want to go to those places. So I get appointed to represent one of those little girls or boys, and I do my best to argue to the court that you're locking this person up, and that's a grave violation of their civil rights, and this shouldn't happen. And then the guardian program, DCF, and often the parents all stand up to the court and say, we can't she's just going to run away again. 99% of the time I lose those. But it doesn't matter to me. That kid is now getting representation. It's no longer a bunch of grown-ups telling them what they have to do. And sometimes you see a little bit of behavior change in those kids. But yes, I go into court and I make ridiculous arguments about why these kids should be allowed to go out and essentially run away again, even though they're exposing themselves to some pretty dangerous things. And that E one, you'd be amazed how often that comes up. A victim of human trafficking. It's really bad. Okay, so I think I hit it right at 1. I know I talked really fast, but I wanted that attorney ad litem thing to be there so you understand that the kids sometimes have their own attorney in there to go into court and to make arguments and to write motions on their behalf and try and get things done, and they're supposed to be getting certain services. From a parent's perspective, again, you're at least in this for a year. I know I skipped right to the termination of parental rights part, but sometimes in that dependency part, you do get reunified. And it's, once you do get reunified with the kids, you've got a term of 6 months that DCF is going to continue to monitor you. It's called 6-month post-placement supervision. And that reunification quite often takes a year. So you're really looking at like a year and a half of this being a part of your life. There's also something else that's called permanent guardianship. It's similar to the termination of parental rights. It's kind of a combination in between where the kids don't come home to you. Everything closes out. And then you on your own got to go out and pretty much out of your own pocket, you've got to pay for the domestic violence classes that you didn't complete or demonstrate that you've been going to enough AA meetings or something like that. And then you can go back as a parent, ask to have the case reopened. If the judge does reopen it based on the evidence, then you got an attorney again. Or you can, in the clerk's office, walks people through how to do this all the time. So that's as much information as I could pack into that short time period. Yes?
When you're representing the parents and have an attorney-client privilege, and in the context of that, information is provided to you that is not yet apparent to the state, and yet you're advocating for the parents sustaining their parental control and possession of the children. How do you balance that with the child's best interest and your duty to the court?
Well, I mean, you're always going to have the duty of candor to the court, but I think attorney-client privilege carries the day there. I had actually I won't say the names of who they were, but this mom and dad that were fighting like cats and dogs, and the mom was a large woman, and she showed up one day in my office with a new baby, and nobody knew where the baby came from. And then she told me where the baby came from, and it came from that dad she's always in court fighting with. And attorney-client privilege carries the day there. I got to keep that to myself. I can't call DCF and say, hey, you got another kid in this family. So, and it's like being a public defender with some of the worst clients in the world. You know, you have a duty to the Florida bar to maintain that attorney-client privilege. So, Andrew?
What is the standard?
It's a probable cause that there's abuse, abandonment, or neglect, or that abuse, abandonment, or neglect are imminent. So probable cause is one of the lowest legal standards that we have. It's even really less than, I don't know, I might ask one of the judges to define it. It's very low. And you remember these reports that are being presented are written by people who professionally write reports about child abuse. So even if there's something that's being slightly exaggerated, it's worded in a way that the judge is likely to grant a shelter. You always can, it has to be revisited, and you continue to revisit it and try and fix it as you go on. Quick funny story. At the beginning of the pandemic, when we only had very few people were allowed in the courthouse, these types of hearings were still going on in the courthouse. Judge Moreland, who's going to be our new chief judge, she was doing all of these hearings, and I happened to be in the courthouse. I wasn't there for one of these, but she set a shelter review in 30 days. And I said, you know, just a friend of the court, the statute says 72 hours by a presiding juvenile judge. And Judge Moreland turned to the state and said, what do you say to that? And the state kind of shrugged their shoulders. 2 days later, we had a new administrative order that all circuit and county judges are considered juvenile judges for the duration of the pandemic, because Judge Moreland said, oh, well, that's what the statute says. That's what people's rights are. So we got to make sure we respect that. Oh, Judge Nicholas.
Can you make a quick pitch for guardians ad litem, briefly explain what they are and the desperate need?
The guardian.
This group of, if anybody within this group thinks they might know that has that.
The guardian ad litem program, and I know they've come and presented here before. It's like a state, like I said, it's state run. It's similar to DCF, but they rely heavily on volunteers in the community who go out and meet with these kids while they're in foster care. They don't get appointed to every case. If the kids are remaining with family members, quite often the guardian program needs to keep their resources for other folks. But it's a lot. You go out, you meet with the kid, you're given access to the Guardian Fund, which I don't know how much is in there, but you might be able to go back to the program and they'll give you money to buy somebody football cleats or something like that. And then it is every 90 days I was talking about, you go back into court for judicial review, and when we're telling the whole story of what's going on, the judge wants to hear from those volunteers. So if anybody wants to find me afterwards, I can direct you to the Guardian Ad Litem program, but like I said, they do rely heavily on volunteers.
Sean, you said earlier about representing the kids, like so you're representing the parents. Is there another attorney representing the kids?
On some cases, I do parents. Some cases, I do the kids. The kids are entitled to, at any point during this 18-month process, any person involved with the case can request that an attorney ad litem get appointed. But what you really are relying on then, 99% of the time, is you're relying on, well, if you're requesting it underneath that statute that I put up there, then the Guardian Ad Litem program is responsible trying to find somebody who will do it pro bono, and then if not, the judge can make an appointment, and that person will then have access to state funds. You can request the appointment of an attorney ad litem for a kid not underneath that statute, but then you're going to have to find somebody to do it, most likely pro bono, unless somebody else wants to come up with some money. And you can't represent the parents and the kid at the same time, because quite often their interests are not aligned. Quite often they are, but I've got one right now where kid just doesn't want to go back to mom. And she's like 15, and she doesn't feel like anybody's listening to her. And so my job is to explain to the judge, the mediator, the other attorneys, or anyone who will listen, that this is going to go south real fast if this kid goes home today. So, sir.
Kids coming in the awards of the state, right?
Yes. Yeah, DCF becomes responsible for them at that point.
Is that, when you turn 18, they're set free? But isn't there a program that could be pushed in place where these kids can understand and know that they can still go forward, get into trade school or college, and still be supported by the state?
There is a thing, like I said, I could do this for 3 days. There is a thing called the independent living docket, where we take kids who are close to aging out of foster care, and they are introduced to things like that. And there's extended foster care where kids can stay, I want to say, until 19. And then sometimes these kids make special bonds with this foster family that was taking care of them, and then that foster family says, we're not fostering anyone anymore, but we are keeping you. So they let their license lapse so that nobody else gets placed there. Now they just sort of take over that kid's life. But there are things in place for that.
Our tradition, handing you the golden ruler. Thank you very much for an interesting perspective on the foster care program. Thank you very much. Thank you very much to Sean. He was a pinch hitter just a week and a half ago. We had a change in our schedule, and he jumped right in there, and thank you very much for giving us a very interesting program. Next week, we're going to have Malcolm Edwards from Seaport Manatee with us to talk about the Seaport. So everybody have a great week, and we will see you next Tuesday here at noon. Thank you. We are adjourned.